following program is classified G. It's suitable for all ages.
Tonight, we explore the question on labour rights and the laws protecting labour in Sri Lanka. In the recent past, the world, alongside our country, witnessed the brutal effects of the pandemic, which took a heavy toll on the workforce. But what are the rights entrusted to an individual part of this workforce? Does it take a back seat during a turbulent time period? How can we as a country enhance these rights to cater to the development? Welcome to Law, Land and Liberty, where we are keeping with the promise of bringing in a contemporary legal topic and breaking it down amidst a veteran in that field, a professional. And the topic we have taken up, as you would have seen within our headlines as well, is something that has been within the foray, within discussions for quite some time, specifically given the pandemic situation. And that is the labour rights and what our workers' rights have been and how it has been affected over time by the pandemic, and what exactly is the legislative framework in play to protect these workers. And now that is an important aspect that involves almost everyone within this country, and we have an individual who is capable of giving us a comprehensive understanding of this, Professor Sarveswaran from the Faculty of Law in the University of Colombo. Thank you so much, sir, for joining us today. As we go into the program, what we want to do first is, as we usually do, establish what exactly the pathway we are going to take in this discussion. So we're going to firstly start off with the contract of employment, then move into terms and conditions of employment. Third, talk about termination and the relevant aspects to it. And finally, talk about trade union rights. Those will be the key aspects that we'll be looking at within today's program.
Hello, my name is Avindra. I am an LLB graduate and a reading attorney at law. My question is about the contract of employment. Is the contract of employment binding in Sri Lankan law?
All right, Professor, a lot of things to discuss today. Again, thank you so much for joining us. My first question, Professor, now contract of employment. A complex subject, and as one would witness, a wide array of legal elements present in this. Where do you start when I bring up the question of what is meant by the contract of employment? How do we start this discussion?
Lalit, actually, you have very correctly pointed out, when it comes to the legal regime of labour of Sri Lanka, it is very complex. Yeah. There are so many statutes involved. So when it comes to the question that you have asked, what is meant by a contract of employment? It is simply the letter of appointment that the employees have. Okay. So then the question will arise whether there should be a written contract of employment, whether it is a mandatory requirement to have a written letter of appointment to create employer-employee relationship. Yeah. So the answer is no. Okay. So there is no such legal requirement to have a written contract of employment. But when it comes to the labour legislation of Sri Lanka, there are so many labour statutes we have. One is the Shop and Office Employees Act.
Shop and Office, yes.
The Shop and Office Employees Act is the only legislation which requires the employers to give a written letter of appointment. But all employees are not covered by the Shop and Office Employees Act, because there are employees working in various other workplaces. But the Shop and Office Employees Act applies only to the employees who work in shops and offices. Okay. So that is the Shop and Office Employees Act is the only legislation which requires the employees to give a written letter of appointment. But then when it comes to the employees in Sri Lanka, generally the employees who work in offices have the letter of appointment. But the employees who work in shops do not have the letter of appointment. Whether they have letter of appointment or not, the employee-employee relationship will be there. Okay. So the simple answer is contract of employment means generally the letter of appointment, but it is not a mandatory legal requirement in Sri Lanka to have a written contract of employment or written letter of appointment to have employee-employee relationship. Even though there is no letter of appointment, so the labour statutes will apply, so the employees will have all the rights.
Okay. Professor, on that line, if I ask a substitute question pertaining to, now you mentioned shops and offices, that's what's specified within this act. When it comes to the other occupations, which may not involve those physical elements, what are the other acts that we should bear in mind? What are the other acts that govern, the other areas of employment?
It depends on the workplace.
Okay.
But as I said earlier, so the Sri Lankan system is very complex.
Yeah.
I will give an example. So we will take an estate, tea estate, right? In Hatton we will say, and the tea estate has a factory.
Yes.
And the factory has an office. So when it comes to the particular workplace, so the employees who work in the factory come under the factory's ordinance when it comes to their health, safety and welfare.
Yes.
But when it comes to their terms and conditions of employment, we have to go by the wages board decisions. There are wages boards under the wages boards ordinance. So we have to go by the decisions made by the wages boards. So in Sri Lanka, we have about 44 wages boards for different trades. So different decisions.
That is different sectors, different occupations.
Occupation. But when it comes to the employees who work in the office of the factory, they come under the Shop and Office Employees Act.
All right. I think this is a very clear beginning for the discussion, Professor. Now, my next question, before actually two questions I want to give it to you together. The labour courts, labour tribunals, a word that we hear across the country. We hear about it, but we don't really know how it works, because when we want to report an offence or anything, it's basically the police that we look at. So we don't really know the structure and the method to be followed. Now, Professor, firstly, if you could mention what is the mandate of a labour court, and then we will move into whether how a contract of employment is received by a labour tribunal. What is a labour court, and where does it fall within the hierarchy of courts in the country?
Danny, this is a very good question. Actually, when it comes to a labour tribunal, in Sinhala we say Kamgaru Usavi, actually Kamgaru Vinisa Sababa, in Tamil we say Tolil Niyaya Sabha. So labour tribunal, actually we have labour tribunals established under the Industrial Disputes Act, and we have labour tribunals everywhere in Sri Lanka. So generally, when it comes to labour tribunals, the people say Kamgaru Usavi, labour court, and they think we can go to a labour tribunal for any matter relating to employment. No. So when it comes to the labour tribunals, I would say more than 80% of the cases, maybe 90% of the cases, go to the labour tribunals with regard to termination of employment.
Okay.
Termination of employment. So about more than 90% I would say will go regarding termination of services or termination of employment. So the other one is when it comes to gratuity.
Okay.
So if there are less than 15 workers in the workplace, the workers in the workplace will not come under the Payment of Gratuity Act.
Okay.
So then they have to go to a labour tribunal if their gratuity is not paid at the time of termination of employment.
Okay.
The other one is when it comes to any deduction from gratuity, forfeiture of gratuity, that also will go to a labour tribunal. But when it comes to a labour tribunal, a workman can go to a labour tribunal, or a trade union on his behalf can go to a labour tribunal. But when it comes to a labour tribunal, it is very much different from the other traditional courts we have, for two reasons. One reason, a labour tribunal is not bound by a contract of employment. So if the contract of employment or letter of appointment has unreasonable clauses, the labour tribunal can disregard the contract of employment and make the decision. The other one is, generally the other courts make decisions, but labour tribunals will have to make just and equitable decisions.
Okay.
So when it comes to these two aspects, the labour tribunals differ from the other traditional courts that we have in Sri Lanka.
Okay, Professor, if you could explain a bit more pertaining to how they differ now. One would assume when it comes to a magistrate court, it's a bit clearer when you say, okay, these are the summary hearings that we can go to. These are the criminal cases goes to this specific area. When it goes to a commercial issue, we have to go here. When it comes to a labour, like issue pertaining to labor, what are the characteristic features that you look to within a case? What do judges look to? What are the factors that determine a case when it comes to, if at all they are not bound by the contract of employment, then what exactly are the factors that judges look into?
Yes, actually the reason behind this, when it comes to employee-employee relationship, right? So there is unequal bargaining power between an individual employer and individual workman.
Okay.
So because of the unequal bargaining power between the two parties, the employers can include the clauses that are very much favorable to them.
Okay.
So then what will happen is, then there could be an exploitation of workers by the employers.
Okay.
So because if the labor tribunals accept the letter of appointment or the contract of employment, then what may happen is the employers may include the clauses that are very much favorable to them.
Okay.
Because using the unequal bargaining power between the two parties. So that is why the particular legislation, the Industrial Disputes Act provides that the labor tribunals are not bound by the
Okay.
contract of employment. But here when it comes to the labor tribunals, I said they have to make just an equitable decision. So then, for an example, if it's a termination case, goes before a labor tribunal. So the labor tribunal will consider the facts and hear the evidence.
Yeah.
And then it will make the decision, So we have one thing we have to remember, the labor tribunal, some people think that it is to make decisions favorable to the employees. No. So it has to balance the interests of both parties. We can't have employers without employees. We can't have employees without employers. So it is balancing the interests of both parties.
Now, Professor, again, before I want to ask a question on the retirement age issue and how exactly that has been affecting the contract of employment. Before we go there, Professor, this the issue of equitability that is given to employees. Now, how? If it is not by the contract of employment which an employee might subscribe to, they might agree, sign it or whatever, and they believe they are bound by it. How does that even if they have signed, if I'm understanding this correctly, even if they have given some written approval, the courts can mention, no, there is an unfair bargaining power here. Is that what you're mentioning, Professor?
That's right. Even though the employee has signed the letter of appointment, so it does not mean that he has accepted everything.
Okay.
For an example, now when it comes to the letter of appointment, sometimes the employers may include clauses. For an example, we will say, the employees in in Sri Lanka, they have right to form a trade union.
Okay.
And right to join in a trade union. Okay. So when it comes to some places, there in the letter of appointment, it will say, right, you can't form a union or you can't join in a union.
Okay.
That is illegal.
Right.
That is violation of the law. So when it comes to that situation, the particular clause in the contract of employment is illegal.
Okay.
So sometimes some clauses may be unreasonable.
Okay.
Not illegal, but unreasonable, not acceptable. So the labor tribunal will ignore that. So, but if it is illegal, definitely it will ignore. But when it comes to unreasonable clauses also, paragraphs in the letter of appointment, so that because otherwise if the labor tribunals are bound by these unreasonable clauses, then they can't make just and equitable decisions.
Right.
That is the reason.
Okay. Professor, moving on, the next question is pertaining to, I believe, the recent legislation that has been brought in to change the minimum age. Exactly how does that affect the contract of employment, Professor? And we can go into details of how the elements of contract of employment also afterwards.
Yeah, actually this law has been passed in November 2021. So actually it has been certified by the Speaker on the 17th of November 2021.
Okay.
So firstly, it applies to the private sector, not to the government sectors, only to the private sector where 15 or more workers are in the workplace. So these are the conditions, private sector and also 15 or more workers in the workplace. Then it says, but until this law has been passed, until this legislation has been passed in Sri Lanka, we didn't have the legally defined age of retirement to the employees in the private sector.
Okay.
So we didn't have any law to prescribe the minimum retirement age for the employees in the private sector.
Okay.
But generally in the letter of appointment, the employees used to include 55 or whatever. But for the first time, this law has been passed to prescribe the minimum retirement age by law.
Okay.
So then according to this law, now the minimum retirement age is 60.
Okay.
So that means now if the employee who is in employment now is below 52, right? If he is below 52 now, who is in employment now, or when it comes to the new recruitments and all, the new employees, so this will apply. So now the minimum retirement age is 60 when it comes to the employees in the private sector. But more than that, there are many other things also have been introduced. When it comes to the probationers, when the permanent employees are recruited, so they are kept under probationary period at the initial stage of their employment.
Okay.
For the first time, this law says when it comes to a probationer, so the probationary period could be not exceeding 180 days.
Okay.
But again it says, but if the employer can extend the probationary period by another period again not exceeding 180 days.
Okay.
So for the first time, this clause has been introduced.
Okay. Professor, as the last question for this segment, I want to ask you now, if we take the flip side of this from the employer's point of view, what are the elements that the employer should be concerned about putting into a contract of employment? Now, in today's world, there are a variety of benefits given to workers, such as not privileges, but like insurance schemes, or again things like the minimum retirement age, what their job descriptions are. What are the things that should be included in a contract of employment, even though if it's not binding? What are the things that the courts look at?
No, actually, when it comes to a letter of appointment or contract of employment, there are many things. It depends on the nature of the employment also. But those days I used to go, before this legislation has been passed, I used to tell the employers, you should include the retirement age.
All right.
But now anyway, no need, because it is already in the law.
Yeah.
But even there are, generally the employers include, EPF, ETF and all. But, whether they are in the contract of employment or not, the employer has a statutory obligation to pay all these things, make all these contributions.
Okay.
But generally they include those things. And also the employer can include about maybe about misconduct and all.
Okay.
And also transfer, whether, right? Even can include, when it comes to, vacation of post,
Right.
And also it can include, when it comes to suspension of services, pending disciplinary inquiry, whether the wages will be paid or not, right? So, and also working hours and those things. Okay.
Multiple elements are there.
Yeah.
I think a very good the introduction we have been given to this discussion. Professor, let's take a very short break. You're watching Law, Line and Liberty. Stay with us. Welcome back to Law, Land and Liberty. We are in conversation with Professor A. Sarveswaran from the Faculty of Law in the University of Colombo. Professor, the next segment we want to take up is on the terms and conditions of employment, primarily the external factors, by be it the government or the individual rights that are in play. The first thing that we want to clarify, Professor, now, one clarification you did make was there are multiple types of jobs. The Shopman Officers Act includes a certain amount and based on the location. The minimum age to make an employment has unfortunately not been too clear amongst the people within this country and multiple other countries. Now that differs to domestic work, to work in offices, to commercial activities as well. Provide us some clarity there, Professor. How exactly is the minimum age for employment defined in Sri Lankan law?
Yeah, when it comes to the minimum age for employment in Sri Lanka, until January 2021, it was 14 years.
Okay.
14 years.
That is across domestic or commercial, regardless of what the occupation is.
Occupation,
Yeah.
But except some occupations which are dangerous
Yes,
to health, safety, and morals of the child. So then, otherwise, 14 years until January 2021. But in January 2021, maybe about 3 or 4 labor statutes have been amended. So after that, now it is 16 years. 16 years, the minimum age for employment. But then it does not mean then a child above 16 years could be employed in any type of employment. No. But again, in November 2021, actually on the 18th of November 2021, there was a Gazette regulation, right? Gazetted under the Employment of Women, Young Person and Children Act. So it says when it comes to those categories of employment, right, there are more than 70 categories of employment in which a child below 18 years cannot be employed.
Okay.
A child below 18 years cannot be employed in those categories of employment. For the first time, we have included even domestic workers also there.
Okay.
So now, after this regulation has been gazetted, a child below 18 years cannot be employed as a domestic worker also. Below 18 cannot be employed as a domestic worker also. But also there are so many other restrictions, you can't employ a child in night work and all, right?
Yeah.
So those are some restrictions.
Some of the restrictions.
But anyway, that does not mean when it comes to female workers, above 18 could be employed. When it comes to the female workers also, there are many restrictions.
Yeah. If possible, Professor, anything that comes to mind, if you can mention what these restrictions are, so we can get, since most of our audience is about laymen and laymen trying to understand the law, what are these restrictions that are in play when it comes to male and female, the distinctions that have been made, whatever you believe you can share with us?
Yeah, when it comes to the males, of course, above 18, they could be employed in night work and all.
Okay.
But when it comes to the female workers, mainly there are two legislation. One is the Shop and Office Employees Act.
Okay.
Other one is the Factories Ordinance. So when it comes to the Shop and Office Employees Act, it says a female worker above 18 years could be employed in night work. But again, there's a limitation. It says when it comes to a shop or office, a female worker above 18 years could be employed in night work, but up to 8 p.m.
Okay.
Up to 8 p.m. So then actually recently I have written an article also. Even there also I have mentioned, if we are going to strictly enforce this law, then many female workers will lose their employment.
Okay.
Now these laws and these regulations and all have been passed during that time. But now the things have changed, right?
Okay.
So then when it comes to the factory workers, there it says a female worker above 18 years could be employed in night work, but there are many restrictions. One is maximum 10 days in a month.
Okay.
Of night work. And also female warden should be there, the consent of the female worker should be obtained, and the approval of the commissioner should be obtained, and also 1.5 times of the normal payment should be paid. But anyway, still, not more than 10 days in a month of night work.
Right. Professor, I think we went a step ahead, but when we take the differentiation between the contract of employment and the terms and conditions of employment, how does that differentiation actually happen, and how do you make that justification about what the terms and conditions for employment are? Now we spoke about minimum age. I think it's a big question that you really shed a lot of light on. How do you really explain what terms and conditions for employment are?
Yeah. Actually, I mentioned about contract of employment earlier, but when it comes to Sri Lanka is a welfare state. So the welfare state means the state intervenes to protect the weaker party of the society.
Yeah.
So when it comes to the employee-employee relationship, the employees come under the weaker party of the society. So the state has enacted many labor statutes to provide for the terms and conditions of employment. For an example, if we take the Shop and Office Employees Act, so that particular legislation provides for many things: working hours, overtime hours, leave entitlements, even overtime payments and all, right? So when it comes to these terms and conditions, maternity leave, so all these things, when it comes to maternity leave also, actually the labor statutes have been enacted amended in 2018. Until June 2018, even when it comes to the Shop and Office Employees Act also, a female worker can have maternity leave for 84 days, up to 84 working days, when it comes to the first 2 babies.
Okay.
Thereafter, it was 42 working days.
Okay.
Right? So the same under the maternity benefits ordinance also, there it goes by weeks. But in 2018, in June 2018, these 2 labor statutes have been amended. Now that restriction has been taken out. So now, when it comes to any number of babies, so the female worker will have 84 working days under the Shop and Office Employees Act. So I think it is a positive development.
An important development.
Yeah. So when it comes to the question you have asked, the terms and conditions of employment may come under contract of employment also.
Yeah.
The letter of appointment also the employer can prescribe. But more than that, I would say in Sri Lanka, the labor statutes prescribe. These are the terms and conditions of employment.
Yeah. Yeah.
So then when it comes to the employees who come under the Shop and Office Employees Act, the Shop and Office Employees Act provide for all these things. When it comes to the employees who come under the wages boards and also the wages boards can make decision on these matters.
All right. Professor, in that regard, do you believe that the terms and conditions are not set in stone, or is it that there are relevant acts to govern almost all occupations? Because my question here comes with, now if you look at the Shop and Office Act, pertaining to employment, does that really flesh out everything that is required pertaining to a person that falls into that category of shop and office? All the terms and conditions that govern it are present within that act, or should we look at multiple other acts in that?
No, mostly, coming under the Shop and Office Employees Act, sometimes you may say, okay, but what about EPF, ETF, gratuity and all?
Yes.
So for those matters, we have different legislation. Even for an example, even we have a legislation passed by Parliament that is about the minimum wages of workers. But that now that says 12,500 now. Earlier it was 10,000 for a month, but now it is the minimum wages.
Okay.
And also there is another legislation about Budgetary Relief Allowance Act, regarding budgetary relief allowance. And also depending on the nature of the workplace, there could be some other allowances, some other incentives and all. But those are not in the labor statutes. So then the letter of appointment becomes an important one when it comes to those matters. Even when it comes to gratuity also, the Gratuity Act says now the gratuity will be calculated on the basis of half a month's salary for 1 year service.
Okay.
But some places they pay double.
Okay.
So we call it enhanced payment of gratuity. Okay. So that could be in the letter of appointment.
Okay. So there are, we will read the letter. It's again, I think you're explaining what the complex reasons in these areas are. Professor, if we take a step forward now, we did talk about the power dynamics between the employer and the employee. And within a workplace, multiple issues may arise, and one of them would be the sexual harassment issue that has been prevalent and that requires protection of both entities, male and female. How does the Sri Lankan law cater to those issues, Professor? What exactly are the legislation we look into? Is it criminal law that we're going to look into, or does labor tribunals have any sort of jurisdiction over these issues?
It is a very good question. So now at the beginning I said there are so many labor statutes we have.
Yeah.
But at the same time we have many gaps also in the labor statutes.
Yeah.
One is about the question that you have asked. So when it comes to the labor statutes in Sri Lanka, we don't have any provision in the labor statutes dealing with sexual harassment at workplace.
Okay.
So that means our labor statutes have not recognized this is a labor issue.
Mm-hmm.
So we don't have any legislation at all. Okay. But we have the penal code, the criminal law. Penal code, section 345 says sexual harassment is a criminal offense, punishable criminal offense. But when it comes to the penal code, it comes under the criminal justice system.
Yes.
So, but there I would say, when it comes to the penal code, then you have to make a complaint to the police. Then there is the procedure and the burden of proof, standard of proof, with the stigma attached to all these things. Yeah. So generally the female workers do not go and make complaint. That generally it doesn't happen like that. Yeah. But then in my opinion, so what we have to do is we have to amend the labor statutes, because we have to amend the labor statutes and include a clause in the labor statutes to cast an obligation on the employer to take measures to prevent sexual harassment at workplace. Okay. So, but as it is now, we don't have any provision in the labor statutes, with regard to sexual harassment at workplace. Okay. And also the other one is very recently, not recently, about 2 years ago, the ILO, the International Labour Organization, has adopted another important convention, the International Convention regarding violence and harassment at workplace. Still, Sri Lanka has not ratified the convention, but I strongly feel that Sri Lanka should ratify the convention, and the legal provisions should be incorporated into the labor statutes to deal with violence and harassment at workplaces.
Right. A lot of important things that we have highlighted within that segment as well. Professor Sarveswaran will take a very short break. You're watching Law, Land and Liberty. Stay with us.
Hi, I'm Vasantha. I'm reading for Bachelor in Business Management degree. My question is about termination. What are the rights awarded to employees to address wrongful termination?
Welcome back to Law, Land and Liberty. We are in conversation with Professor A. Sarveswaran. Professor, our next segment we are going to talk a bit about termination of employment. Now it's a vast area, an important area that we need to touch on. As a approach to this segment, I want to ask you, Professor, about the EPF ETF provisions, as in it's sort of like an allowance made to employees. One would call it the superannuation of allowances. And we can talk about retirement and everything also. The benefit, how is it exactly mentioned within law, Professor? What exactly is the requirement placed on the employers to have this provision made? Is it part of the salary, or how does it exactly work, Professor?
Yeah, actually, it's a very good question again. So when it comes to the workers, mainly the workers in the semi-government sector and the private sector. Yeah. So when it comes to the workers in these two sectors, generally they don't get pension, so they get these statutory benefits. So some people say retirement benefits, some people say termination benefits. And so when it comes to EPF, right? So then it is paid based on the earnings of the month. So basic salary, cost of living allowance. So if there is any allowance called food allowance and all, that will be, even the budgetary relief allowance will be added. And also if there is any pay for unused leave and all, so that also will be added. So generally based on these things, the calculations will be made. So according to the particular legislation, so the employer will have to contribute 12% of the earnings. Okay. Employee will have to contribute 8% of the earnings.
Of their salary, that is?
Yeah, okay. Yeah, salary. So then, when it comes to the employer and the employee, even some places, so the contributions are not made. So then what will happen? In that case, later, the employee may go to the Labour Commission and make a complaint. Okay. So when it comes to the period to make the complaint, there is nothing. So the employee can go even after 3-4 years or 5 years, to make a complaint. But when it comes to labor tribunals, termination cases, a workman will have to go within 6 months. But to claim EPF, ETF and all, there is no such time period. So once the employee goes to the commissioner and makes a complaint, then the commissioner will order the employer to make his contribution, that is 12%. The 8% contribution the employee will have to make now. So now the employee has left the workplace. Okay. So now the employee will have to pay that also from his money. Right. Because the law says it is the obligation of the employer to deduct from the employee's earning and contribute. Okay. So the statutory obligation is on the employer to make it. And also then the surcharge also will be added. Surcharge. Additional amount. So when it comes to EPF. But many people think when it comes to EPF, they think if there is no letter of appointment, then they are not entitled. That is wrong. Okay. Even though there is no letter of appointment, the EPF contribution should be made. Okay. The other one is, some people say when it comes to temporary employees under these fixed term contracts and all, not entitled. No. They are also entitled to EPF. So when it comes to ETF here, but only the employee will have to contribute 3%. When it comes to gratuity, there we have two legislation. One is the Payment of Gratuity Act. So it says if there are 15 or more workers and the workman who works in the workplace has completed 5 years of service, then the gratuity should be paid at the time of termination. But it should be paid within 30 days from the date of termination. Mm-hmm. But if there are less than 15 workers, then they are not coming under the Gratuity Act. Then those workers will have to go to a labour tribunal to claim gratuity. So these are the important provisions relating to EPF, ETF and gratuity.
Yeah, thank you, Professor, for making those clarifications. I think that's a very important aspect to understand. Now, moving to the termination of employment, Professor, again, multiple areas that we need to look at. The first thing that we would want to look at is the types of termination. Now, one would not be clear about whether there are multiple types, or is it just a blanket statement? How do you approach the termination aspect? What are the allowances made for employees, employers? How does termination really work in Sri Lanka?
So when it comes to the types of terminations, there are many. Yeah. So one is, disciplinary termination. Yes. That is, termination for a misconduct. But an employer can't terminate a workman for each and every misconduct, but it should be, a serious misconduct, or it should be a habitual one. That means even after warnings, then only can go for disciplinary termination. The other one is non-disciplinary termination. So when we say non-disciplinary termination, because of the COVID-19 pandemic, it happens in many places. That is, there are mainly two types. One is the closure of the business. So the employer has closed down the business. The other one is we say retrenchment. That means the employer has terminated the employment of the workers who are redundant in the workplace.
So reducing the staff.
To reduce the number of workers in the workplace. So these two come under non-disciplinary terminations. The other one is vacation of post.
Okay.
That means the worker does not report to work beyond reasonable period of time without any reason, valid reason. That is called vacation of post. The other one may be constructive termination. When it comes to a constructive termination, the employer does not terminate the services of the workman by giving a letter of termination, but the employer creates unbearable or intolerable condition that forces the workman to leave the workplace, which is considered as constructive termination by the employer. Right? And also there could be some other forms like maybe because of the operation of the law. Operation of the law. Sometimes the law will prohibit certain things, then thereafter the employer can't continue that business, then the workers in the workplace will lose their work. And also sometimes frustration also. Frustration also. Frustration means, maybe because of natural disaster or whatever, the factory has been destroyed and also it is beyond the control of the two parties, So
Professor, in extension to what you were mentioning, the pandemic situation would have resulted in maybe these issues or maybe even new issues that have come up for employers pertaining to how they have to handle their employees. Is there new legislation pertaining to this? How has the country really identified the pandemic? How has the workforce been, changed pertaining to how to be flexible with the pandemic situation?
No, actually, when it comes to the pandemic situation, actually it was not expected one. We never expected, we will have this situation. But when it comes to labor issues, I would say, because of the pandemic, many labor issues have emerged.
Yeah.
But when it comes to many labor issues that have emerged, we don't have the answer in the labor statutes. For an example, even during the pandemic time, lockdown time and all, even when it comes to some workplaces where the employers could not continue to provide work to the workers. So when it comes to that situation, the issue was whether the employers would pay their full wages.
Yeah.
Because they were not invited for work because, it was because of lockdown or other reasons. So then when it comes to the answer, it is, no answer. But anyway, there was an understanding among the stakeholders, mainly the trade unions, the government and the employers to pay 14,500 or 50% of the basic salary, whichever the higher.
Okay.
But anyway, that has no legal validity actually. That was an understanding, among the stakeholders. But anyway, that is no more. So when it comes to the labor issues that have emerged, even another one I would say, when it comes to biological hazards.
Okay.
So we don't have any legislation, labor legislation, to deal with that, when it comes to this COVID-19 and the obligations of the employer to take measures to protect the workers from this. But anyway, when it comes to the question that you have asked, we have not passed any labor legislation or we have not amended any labor legislation to deal with these issues. But only one, I would say, when it comes to the, the pandemic situation and the health and safety measures, under the Prevention of Diseases and Quarantine Ordinance, the Minister of Health has gazetted a regulation in October 2020 with regard to the obligations of the employer also. Right? So the particular regulation says the employer will have to ensure that all are wearing masks and also washing their hands, and there are certain things. That is the only one. But other than that, we don't have any labor legislation or anything that has been introduced or amended to deal with the labor issues.
Professor, before we move further on this aspect, I want to make a quick clarification now for the public sector and the private sector. Does the aspects of termination of employment differ when it comes to the law, and how exactly is that differentiation made?
That's a very good question actually, Danit, because when it comes to the public sector employees, the very important thing is the public sector employees, if there's termination, they can't go to a labor tribunal.
Okay.
It is very, very important. When it comes to the public sector employees, they can't go to a labor tribunal for relief against termination of their services.
Okay.
Right? But the public sector employees, they can go to the Public Service Commission or they can go to the Supreme Court or they can go to the Human Rights Commission.
There's the private sector, is it?
No, public sector.
Public sector.
Public sector.
Okay.
Or to the ombudsman.
Oh, right. Okay.
But the public sector employees can't go to a labor tribunal.
Right.
But only the private sector employees can go to a labor tribunal. And also when it comes to this COVID-19 situation, there is another important one is, there is another important legislation that we have is that termination of employment of workmen Special Provisions Act. So that legislation becomes an important one when it comes to the terminations that have taken place due to the COVID-19 pandemic. So I said, there are two types mainly, closure of the business, other one is retrenchment, reducing the workers. But the particular legislation says, when it comes to non-disciplinary termination, because the particular statute applies to the private sector employees where 15 or more workers are there, and the workers whose employments are terminated have worked more than 180 days. Okay. Then only they will be covered by that act. But that particular legislation says, if you are going for non-disciplinary termination, closure or retrenchment, reducing the workers, then you have to follow the procedure under the law. What is the procedure under the law? You have to get the written consent of the workers. So there the employer will have to introduce the VRS, compensation package. Then only they will give the, otherwise the employer will have to get the approval of the commissioner. Without one of the two, the employer can't go for non-disciplinary termination.
Right. A lot of important clarifications there. Professor, if before we move into a break, if I may ask you just a final question, for this segment, what exactly are the elements within disciplinary termination? Now, if you can really iron that out, I think that will really give some clarification to this entire segment, because now we did touch a bit on how non-disciplinary termination works when reducing workforces or situations that may arise like the pandemic. For disciplinary terminations, what is the ambit that an employer can really work around? What is the ambit, or what are the questions that an employee can raise?
When it comes to a disciplinary termination, so here, the termination is for a misconduct committed by the workman. So when it comes to a misconduct, generally we say violation of express or implied condition of employment which adversely affects the smooth and efficient functioning of the workplace. Yeah. So when it comes to a misconduct, we have to see whether it is a misconduct, and also, we have to consider various other factors and all. The nature of the employment, the nature of the workplace, and also the position of the employee, and the nature of the misconduct and all. And we have to consider all these factors and make the decision whether it justifies the termination of services or not. Yeah. But sometimes, the misconduct may be outside the workplace, but still it will justify the termination of services. Just I will give an example. One employee in a bank, executive level, he sat an examination. In the examination, he has committed an examination offense. Okay. He had some unauthorized materials in his pocket and copied from that. So then the examination has been cancelled, and it has been informed to the bank. Okay. So thereafter, the bank also has terminated his services. So then when the matter went to the superior courts, the court accepted the termination of services by the bank for the reason of loss of confidence. The bank can't keep that person, the person who has committed examination offense like this, as an executive officer in the bank, because when it comes to the banking sector, the loss of confidence is a ground for termination of services.
Right. Another important clarification there. Thank you so much, Professor. We'll move into our last segment. Before that, we'll take a very short break. You are watching Law, Land and Liberty. Stay with us.
Hello, my name is Dilipa and I'm a software engineer. My question is about trade union rights. How can a legitimate trade union be formed under Sri Lankan law, and what are its limitations?
Welcome back to Law, Land and Liberty. We are in our last segment. We are in conversation with Professor A. Sarveswaran. Professor, this segment will be on primarily trade union rights. Now, it's not a friendly term that has been going around within this country, but we have to really understand the legislative, frameworks in play for how trade unions function. But before that, again, something that we can continue from the previous few segments, Professor, and we would want to get your take on is now there was an act that was passed, and in this program also we really discussed the Port City Commission Act and what exactly the framework that is present there. It's a novel experience for all Sri Lankans. Let's talk a bit about the labour aspect of this, Professor. What are the elements that have been put in play to really cater to investors, to cater to people that may work there in the future? How has the labour rights aspect really taken form within the Port City?
Yeah, that is another very good question that you have asked, because actually, Danny, when it comes to the Colombo Port City, actually, whether we like it or not, we need investment. Yeah. That is my view, because we need investment. So when it comes to investment, the investors will see the labor law of the country also. Yeah. But if you don't have conducive labor law regime in Sri Lanka, then the investors may not come to Sri Lanka. So here, when it comes to the Colombo Port City, that particular legislation, passed by Parliament, provides that exemption could be given from the application of the termination of Employment of Workmen Special Provisions Act within that area. So, when it comes to that particular legislation, some people have the misconception that it doesn't apply to the BOI companies and all. No, that is not correct. But the exemption is given under this, Colombo Port City, this Economic Commission Act, right? So the within that area, there it could be exempted, that the termination of Employment of Workmen Special Provisions Act will not apply within that area. Okay. But even though that particular legislation doesn't apply, all other labor statutes will apply. Okay. If there is termination, the workers within that area also can go to a labor tribunal. Okay. But sometimes you may ask me, what about the foreign workers? But even if even the foreign workers can go to the labor tribunals in Sri Lanka, as long as they work in Sri Lanka, they come under the law of our country.
All right. Professor, the last segment on trade unions. Now, the formulation of a trade union has a certain objective behind it, and that will be primarily to look at the employees' benefits, look at what exactly the employees' rights are. If you can tell us, Professor, what are the allowances present, be it within the contract of employment or within the law within this country, to form a trade union, either in private or public sector? What are the allowances that are present?
Yeah, actually, when it comes to our constitution of 1978, so it provides every citizen has a right to form a trade union and join in a trade union. Yeah. So, but when it comes to the labor legislation, in 1999, the Industrial Disputes Act has been amended. After that amendment, the employees, the workers, have right to form a union, right to join in a union, right to engage in trade union activities and all, and also protection against anti-union discrimination. That means the employer can't discriminate the workers for being members of the trade unions and or engaging in trade union activities. Other one is the right to collective bargaining also. Okay. If the trade union represents 40% of the workers, the employer will have to go for bargaining with the union. Okay. So then when it comes to the labor law regime of Sri Lanka, it provides that the employees have the right to form a union and join in a trade union, but there are some exemptions. For an example, those who are in the judicial officers can't have a union. Okay. And also the police officers can't have a union. Members of the armed forces can't. And also prison officers can't have a union, but all others can.
All right. Okay. Professor, in extension to that now, the simultaneous question that comes up with trade unions is strike action, and that is what is present, and that is what, even if you ask a normal person, that is what comes to their mind, trade unions, and their primary objective would be strike actions. What are the allowances there, Professor? Where does the employer get to make an intervention, and is there a possibility to do that? Or what exactly is the framework there?
When it comes to right to strike, we don't have any labor legislation which expressly provides for right to strike. Okay. But when it comes to our labor legislation, if we take mainly the trade unions ordinance, it says you can have a union, and also when the trade unions go for strike action, the civil action cannot be filed for the consequences of the strike, you know.
Yeah.
So basically, you know, our labor statutes do not expressly provide for right to strike, but they impliedly recognize right to strike. And also our courts also have accepted that. But the important thing is that strike is considered as a legitimate weapon or legal weapon in the hands of the workers.
Okay.
So that weapon, they can't use it for each and every situation, you know.
Okay.
It should be used as the last resort. Last resort.
Okay.
So, you know, there are two things. One is the strike should be a legal strike, lawful strike. Other one is the strike should be a justifiable strike.
Okay.
These two things are there. So, but when it comes to our labor law regime, you know, on the one hand, the workers can have a union and the union can go for strike. On the other hand, there are so many limitations also. There are so many limitations, you know, regarding the right to strike, you know. So the government can intervene and prohibit strikes in certain situations. So we have many statutes for that also.
Yeah, Professor, if you can get clarification now, the justification of whether a strike is in fact valid or not, who gets to make that call, Professor? Is it the employer or is it the tribunal? Where should they go?
That type, of course, you know, it depends on various factors, depends on their demands,
right.
and also depends whether, you know, they have resorted other mechanisms to resolve or reconcile the conflict and all, and depends on all these factors and all. Finally, when the matter goes to the court will have to see whether it is a justifiable strike or not. But if the strike is an illegal strike, then that is an offense, you know. For an example, you know, now the government has, you know, for an example, when it comes to the employees who come under certain categories of employments in the public sector. You know, we have a particular legislation called Essential Public Services Act. So there it says when it comes to the services provided by the government institutions, right? So there's a actually schedule, you know, it says these services will come under Essential Public Services Act. Yeah. So then, you know, the president can go for gazette notification and declare those services as Essential Public Services Act.
Okay.
Under the Essential Public Services Act. Right. So then, it is a matter of one paragraph in the gazette. Once the president has declared the service as an essential public service, thereafter, a trade union in that particular service can't go for strike.
All right, Professor, a lot of clarifications that you have made as we began this discussion. This is a very, very broad topic, but I believe you gave a lot of clarifications and we are very thankful for that, Professor. Professor A. Sarveswaran from the Faculty of Law in the University of Colombo, thank you so much for joining us, and hopefully we'll get to meet again, Professor, again to give this form of clarity to our discussion. Thank you again for joining us.
Thank you for the opportunity.
All right. The path to a nation's success is the will and productivity of its workforce. The protection of this workforce from exploitation is something the law has to take seriously into account. In addressing the unique and important role of labor, Nobel Prize laureate Joseph Stiglitz once stated that the workers' rights should be a central focus of development. That is all from us here at Law, Land and Liberty. If you had missed today's program, you can watch the entire episode on our YouTube channel, youtube.com/Derana English. Join us again next week as we break down a contemporary legal topic. I am Danitha Tanwasa. Have a great night.